Yes.
My Lord, I'm in the core bundle on page 209.
Yes.
And I'm now going to address Mara's attack on the judge's third conclusion. The third conclusion being that the skilled team, having had serious doubts about Beale, but nevertheless trying the examples and finding them they didn't work, just as the skilled person expected, that they would not then embark on an investigation into enzymatic lysis. And we've seen that that investigation research project, would involve various steps, including literature search and/or a series of experiments. Now, the judge's finding was plainly open to him on the evidence, by which I mean he had ample evidential support for it. Can I just show you Dupin 1 in the supplemental bundle? So the supplemental bundle, tab 7, page 210.
Yes.
And this is addressing precisely this question. Paragraphs 139 and 140 provide evidential support for the third conclusion.
Hold on.
Well, are you going to take us to the cross-examination?
Oh, absolutely.
Because the judge says that although Mr. Dupin and Dr. Wim took a negative view of Beale and their written evidence, those views were ameliorated in the answers they gave in cross-examination.
Yes, I am. Yes, I am. I mean, unfortunately, there is quite a bit of evidence I need to go to. I suppose, fortunately, from my point of view, because I'm the respondent.
Yeah,
but no, absolutely.
The reason I asked the question was you said, look at paragraph 139 and 140, they provide evidential support for the third conclusion. Not necessarily.
I see. Your point is well taken, my lord. This is the first bit I want to show you.
Okay.
Yes.
Okay, so that's the context for that provides useful context for the 4 reasons which we're going to look at. But let me just say, by way of overview, given the way my learned friend addressed your lordship this morning, the judge's third conclusion was obviously right when you bear in mind that there was no CGK that enzymatic lysis would have any better prospect for developing a solvent process than any other means of lysis. That, at last, is common ground. And there is nothing in bile to suggest that enzymatic lysis has any better prospect than any other method of lysis for a solventless process. Your lordship's taxed my learned friend on that, and although he didn't say so, he was completely unable to point to anything in bile which would give the skilled person the idea that enzymatic lysis might make any difference on this score. So now I turn to the reasons in paragraph 311 to 315 and my learned friend's attacks on them. So paragraph 311 actually has 2 limbs. The first limb is that Mara's case, as summarised by the judge at 285, appeared largely to discard the rest of the teaching of Beale. And we gave a list of points of that nature in our skeleton argument, which my friend took you to. And my Lord Justice Miles pointed out that A needed slight rephrasing to focus on the absence of solvents. But those points were good points. Now, it's important to understand that the judge's 311 and our points in paragraph 34 relate to the case presented to the judge, which he summarised at 285. And what you see from the case summarised at 285, correctly summarising the case presented below, was that it involved the skilled person simply reading Beale and going straight to enzymatic lysis. Now, my learned friend is rather pivoted to saying that the reason that you go for enzymatic lysis is because you're trying to fix Beale. He said, I hope I'm quoting him correctly, any concerns drive you to enzymatic lysis. And my lords, that new way of putting the case is bad. Firstly, it's contrary to the evidence and findings of the judge that the skilled person would not regard Beale as a credible document on the question of solventless separation. And I showed you 274 to 277, and particularly underlining the finding that Beale does not acknowledge the inevitable emulsion and offers solutions for separation which would not work. So the skilled person has got no reason why they're going to persist in trying to achieve solventless separation with Beale when Beale is manifestly proven to be unreliable on that score. Secondly, if the skilled person did think it worth trying to pursue Beale's goal of solventless separation, despite the examples not working, then they're either going to pursue Beale's own suggestions, which are to be found in paragraph 28, little f, or they're going to pursue the common general knowledge ways of addressing an emulsion, which are set out in paragraph 656 of the judgment, which I showed you this morning. That's what a skilled person trying to cope with the emulsion that Beale gives rise to, even though it doesn't acknowledge, would deal with. There is no evidence that the skilled team would think that the solution lay in the method of enzymatic lysis, and that's a point I have to develop, the no evidence point. But I've already made the point, there's nothing in the CGK to suggest that the solution would lie in the method of lysis, and there's nothing in Beale to tell them that the solution would lie in the method of lysis. On the contrary, Beale, on the contrary. And the judge was absolutely right to say at the end of 311 that Mara's case was not significantly different from a case of obviousness over the CGK concept of enzymatic lysis, because, as I've made the point, the document does not tell the skilled person anything about enzymatic lysis that they wouldn't know already from O-level science. That is an important my learned friend complains, well, why is that a bad thing? The reason the reason why this is a cogent point of non-obviousness is because it is taken in the context of the first two conclusions. After the skill team had tried and, as they'd expected, failed to get Beale to work, the fact that Beale offers nothing more than CGK is a reason why the skill team would not persevere any further with the document. And this finding then feeds into the subsequent paragraphs of the judgment. So I turn to the judge's second point. What was new in Beale was not the mention of the CGK method license, but the suggestion for a solventless separation using centrifugation with the optional addition of one or more salts. The point here is that Beale is pointing the skill team towards the separation stage. Doesn't give them any reason to do anything out of the ordinary at the lysis stage. That's the judge's point, and that's a good point. There is no motivation in Beale to research a new form of lysis, never before used in the context of microbial oil production, and which is not presented by Beale as giving rise to any advantages or differences over the other methods of lysis that are relevant. My lord, the judge's third point is at 313. Now, this court has said that the question, why was it not done before, is always a powerful consideration. That's TECNIP, which is in the authorities bundle. And the judge's third point is that if it was obvious to develop a process for obtaining PUFA by enzymatic lysis of schizoquetrum cells, it would have been done by someone well before 155. Obviously, the judge noted the short gap between publication of the prior art and the priority date, which usually provides the answer to why was it not done before, but it doesn't provide an answer in this case, because so far as concerns enzymatic lysis, Beale added nothing to the CGK. Now, in their skeleton argument, the Mara suggested that the problem with organic solvents was not long-standing, That's just simply wrong, and the evidence references, the judge's findings that it was a long-standing problem are 121, 128, and especially 131, where he said it had long been appreciated that the extraction process would ideally be aqueous. My learned friend tried to put it in a more subtle way, which I think my Lord Justice Arnold struggled with for a while. I still haven't got it. But I think the point was that Beale puts enzymatic lysis into a document mentioning solventless separation. But the judge has dealt with that point. Although it mentions solventless enzymatic lysis, it doesn't tell you anything about enzymatic lysis over and above the CGK. So it's not an answer to the why was it not done before point for that reason. And in particular, it doesn't give the skilled person a reason to think that enzymatic lysis could be part of the solution, as opposed to any other method of lysis. So there really is no answer to why was it not done before. If my learned friend's thesis that the skilled person would realise that the emulsion problem is caused by the violence of homogenisation, and that would be less of a problem with enzymatic lysis, then that would have been done years before, given the fact that there was a long-standing desire for a fully aqueous process. There is no basis for my learned friend's suggestion that Beale gives rise to a new thought process. My Lord, I come to the judge's fourth point, which is the one that my learned friend spent a lot of time on. Can I start by inviting your lordships to read 314 carefully and to add some marking to it? Because it's important to realise that the fourth point is that there is no evidence to support two things. So this is how we read it. Despite Mara's best efforts, there was no evidence to support their suggestion that, one, the skill team on reading Beale would understand the emulsion problem was caused by the violence of mechanical lysis, that enzymatic lysis would produce a gentler emulsion, and two, this thought process would point the skill team towards taking up enzymatic lysis. 1 and 2 are obviously two different things. Merely appreciating that an enzymatic emulsion, an emulsion resulting from enzymatic lysis would be weaker than one resulting from homogenization is not the same as realizing that enzymatic lysis could solve the solventless processing problem. It's an additional step to appreciate that it would then motivate the skill team towards taking up enzymatic lysis. And we say 314 is right on two bases. We say it's true that there was no evidence to support either 1 or 2, and I'm going to show you that. But my learned friend does not even suggest that there was any evidence to support point 2, i.e. that this thought process would point the skill team towards taking up enzymatic lysis. Again, at the risk of repeating myself, none of this was CGK. Beale doesn't say it. So I now hit the no evidence point at last head on. Firstly, none of the experts made such a point in their expert reports. It's particularly telling that Mara's expert, Dr. Kyle, put in 3 reports arguing that 155 was obvious over Beale, but none of them mentioned this as a point of fact or as a reason why the skill team would be motivated to pursue enzymatic lysis from Beale. Dr. Kyle gave other reasons which the judge rejected as hindsight. And it is and just pausing for a moment, it is quite striking that Dr. Kyle's entire evidence on obviousness had to be rejected because it was fueled by hindsight. But even he didn't come up with this point that my learned friend now says would be obvious to an uninventive person. Even he, with hindsight, didn't come up with that. Dr. Kyle also did not mention the point during extensive cross-examination about enzymatic lysis, emulsions and Beale. The judge recorded this at his 281. Furthermore, the point was not mentioned in Mara's opening at trial, written or oral. They did a written opening and they gave an oral opening, and they didn't say that the reason why Beale made enzymatic lysis an obvious thing to pursue was because it produced a weaker emulsion and could therefore be expected to solve the emulsion problem. The point first appeared when it was put to DSM's downstream expert, Mr. Dupin, in cross-examination. And what that chronology tells you was that this was an idea that occurred to counsel when preparing their cross-examination note. Now, my lords, this was blatantly apparent to everyone at trial, and the judge made an express finding that the point was constructed by Mara with hindsight. That's in the judgment at 889, in the context of Hendrick. For completeness, 279 also records that it was sought to be developed in the course of trial as opposed to before trial. So the first sentence of 279 and I believe the last sentence of 889. So, as I say, it was put to Mr. Dupin, and the judge recorded Mr. Dupin's response at 281 Roman 4. And I hope this is the bit of evidence that your lordship was asking me for, my lord. He was adamant that the skilled person would not think in this way. And the judge gives the reference to the cross-examination, and there is more of it in the bundle, but the judge set this out and he underlined two answers because that really gave the reader of the judgment a clear and fair idea of the gravamen of Mr. Dupin's evidence, which is he just simply would not accept that the skilled person would think in this way. Having failed with Mr. Dupin, Mr. Speck then had a go with DSM's upstream expert, Dr. Wynne. Now, my learned friend took you to the transcript. Can I take you to the transcript and make my submissions on that? So we're in the SUP2 bundle, tab 18, and I start at page 469.
Was he actually an expert on this sort of thing?
So he was an expert on the upstream.
Yeah, I know, that's why I'm asking.
Indeed. And the upstream involves selecting the organism. So the decision to use schizoketrin, for example, would be a matter for him. And then how to grow the organism so that you ended up with lots of cells full of oil. Remember, that's two stages. First of all, my friend described it very clearly. You grow them so that you get lots and lots of cells. And then once you get there, you change the conditions and then they fill up with oil. Lysis is not within his area of expertise. He had opined on it because he had been asked to talk about Beale because one of the issues was the choice of schizoketrin. So he was talking about Beale, and even he could see, even he had enough knowledge to know, well, those examples just don't make sense because you're going to get an emulsion, and even I know that. So it was not completely unfair for my learned friend to cross-examine Dr. Wynne about this because he had made that point because it was a point that someone with the barest knowledge. But he was not the downstream person. So that's the context. If it had been a contest between the two, if one had said one and one said the other, there'd be no doubt that you would go with Mr. Dupin, the expert on downstream matters. That point doesn't arise in this case because Dr. Wynne didn't say what my learned friend wished he had said, so it's fine. But if the two of them had said opposed matters, that would be how you would break the tie. And I've shown you Mr. Dupin, both in writing and orally, being absolutely firm on the point. I'm going to refer to the manuscript pages. So the passage starts at 471, line 20. and it goes all the way to the bit that my friend showed you at the end of 477. And in this passage, Mr. Speck is trying to get Dr. Wynne to say that it would be obvious to do enzymatic lysis in light of Beale. And I'm not going to ask you, because it's so long now, I'm not going to ask you to read it, but it's clear from this that Dr. Wynne was against Marr on the point. His evidence was absolutely consistent with Mr. Dupin's. He was prepared to accept that enzymatic lysis might result in a weaker emulsion than mechanical methods, but he was equally adamant that the skilled team would have no reason to and would not pick up and develop Beale's mention of enzymatic lysis. And when it comes to the sound bite that my learned friend relies on at 477, he absolutely did not accept that the skilled team would appreciate that enzymatic lysis would lead to a weaker emulsion. He said if you could get an enzyme system to work, it would potentially be better. It would be better than that, yes. But my learned friend made the deliberate decision not to say to him, and the skilled person would appreciate that. I mean, if you read the previous few pages, it's obvious why my learned friend didn't put that question, because he knew the answer he would get. Be that as it may, he did not put to Dr. Wynne, and Dr. Wynne did not say that the skilled team would appreciate that enzymatic lysis would lead to a weaker emulsion. So that's the first limb of 314. As for the second limb of 314, the judge's 314, this process would point the skilled team towards taking up enzymatic lysis. My learned friend does not suggest, as far as I'm aware, that he got that answer out of Dr. Wynne on any view. So if you take the two propositions in 314 as a composite, I think it is actually fair to say that my learned friend does not claim to have evidence for that composite, in particular the last bit. It's also worth mentioning that Mara could find not one document from before the priority date, even hinting at this point. If it was, bear in mind that that people in the industry had long appreciated that they wanted an aqueous process, and they tried various things and the only things that worked involved organic solvents. Nobody had appreciated or written down any hint that they appreciated that enzymatic lysis might be the key to this. So why is the unimaginative skilled person going to suddenly think it reading Beale, which doesn't contain any hints in that regard? My Lord, please also do not overlook paragraph 315 of the judge's judgment. Overall, it's difficult to avoid the conclusion that there's an undue focus on enzymatic lysis caused by hindsight. Sorry, I'm jumping to another bundle.
That's good. Yes.
The judge was perfectly entitled to come to this conclusion. His first two conclusions, so that's 274 to 277, they are themselves sufficient to justify 315. And finally, on this, I mention also, please don't overlook the factor which is always important, which is the expectation of success. Given the lack of evidence of any of the matters we've discussed, there absolutely would be no expectation of success. No reason for the skilled person to think that enzymatic lysis could be the solution. That, now saying it out loud, that sounds like saying the same thing I've already said, but put in a different way. But
well, the judge doesn't seem to have thought that was an independent issue. Otherwise, he would have mentioned it.
That's a fair comment, my lord, and that's a fair comment, my lord. So once your lordships understand, in particular, the full scope of 314, there really is no basis for my learned friend's attack on the judgment. He had ample evidence to support the conclusions he came to, and the straw that he puts up in the terms of page 477 of the transcript of the cross-examination of Dr. Wynne just doesn't undermine 314 or at all or in its full scope.
What do you say about the point that it's not just the soundbiting cross-examination that's reliable, it's also some of the written evidence?
Yes, so that's in particular his 159. Well, the last sentence, the paragraph 159 of Dr. Wynne's, which my learned friend showed you, which is what your lordship has in mind, saying that there would be a problem with an emulsion, particularly with homogenization. That, of course, does not say that the skilled person would appreciate that enzymatic lysis would result in a materially weaker emulsion in a homogenizer. Now, certainly with hindsight, as my learned friend read it, one can say, well, surely the flip side of that is the weaker emulsion. And I mean, that's obviously a hindsight point constructed by my learned friend, and the judge so found in 889. My learned friend used this sentence as a launchpad for his cross-examination. You see that in page 477 of the transcript. He used it as a launchpad, but he did not get any expert, even his own, and certainly not Dr. Wynne, to accept that the skilled person would reason from that to thinking, without invention or insight, that was that an enzymatically induced lysis would lead to a weaker emulsion. Plus, of course, that's just simply, all of that discussion is simply the stronger emulsion, weaker emulsion point. None of it comes anywhere near the point that the skilled person would appreciate that the emulsion would be so much weaker that you could actually finally unlock the emulsion problem. So the very highest, and this is consistent with 477, my learned friend used that paragraph to try and establish the proposition that the emulsion would be weaker. But he didn't even attempt to use it as a launchpad to establish that the skilled person would thereby be motivated towards taking up enzymatic lysis as an investigation. And that's why I stress that 314 contains both those aspects. Yeah, sorry. My learned friend, Mr. Nizami, has corrected what I said to you a moment. Dr. Wynne didn't say that there would be a problem with the emulsion. He says that there would be an emulsion. And that's why I don't think Beale would work. Because Beale, of course, doesn't acknowledge the existence of an emulsion and offers a method of separation, which the skilled person would know, well, that's not going to work because I know there'll be an emulsion.
You might have quite a thick mayonnaise or a slightly less thick mayonnaise, but it doesn't mean you've got a vinaigrette.
Very well, if I may say so, my lord, very well put. And there's no evidence at all about what the skilled person would think, even if they thought, oh, it could be weaker. There's just nothing on that at all. And that's why the judge was careful to distinguish the 2 points. Would it be thinner? And if so, does that mean it's worth pursuing this document, bearing in mind always that this is a rubbish document, which you've tried out, you've proved to yourself what you always knew, which is that it's rubbish. And at that point, the judge was entitled to say the skilled person wouldn't pursue these things any further. My lord, at the very end of my learned friend's submissions, he turned to the final section of his skeleton argument, which is under the heading 155 is obvious. And that was his attempt to re-argue the case. I just want to make two very short points. One is that at paragraph 55, which he showed you, he purported to set out what our case is. And that bears no resemblance to any case that I and my learned friend have ever sought to put forward. How they think that's our case, I don't know. And then at paragraph 60, 59 to 60, he refers your lordships to some cross-examination, which he showed you this morning, of Mr. Dupin. And in paragraph 60, the submission is that the judge got the sense of Mr. Dupin's evidence wrong. And Mara's totally wrong about that, and if your lordships do choose to read the whole of the passage of Mr. Dupin's evidence, then you'll see that. But the real point is that only the trial judge can properly assess the sense of a witness's answer. And a better example of the approach deprecated by this court in Fage and Chobani would be hard to find than that whole re-argument. So those are our submissions on 155. I'm going to move on to 801 unless your lordships have any further questions.
No, thank you very much.
So on 801, I've already given you the key common general knowledge, which I'm going to invoke when making my submissions. There are three overarching topics to address. First of all, there's DSM's appeal against the finding that 801 was obvious over the Kobzev prior art. That's our ground one, which has A and B, and I'll be addressing that. Then there's DSM's appeal against a finding that a subset of Mara's processes do not infringe. And my lords, I'm going to ask Ms. Nizami to address your lordships on that, which is ground two. Then thirdly, there's Mara's cross appeal, contending that 801 is obvious in light of the Hendrick prior art, and Mr. Speck will open that. So I referred at the start of my submissions to the fact that a solventless extraction process had long been a desired goal in the microbial oil field, but the emulsion problem had proven to be the stumbling block. And 801 finally provided the solution to this problem. And the patent is in the supplemental bundle at tab 1. Tab 2. Supplemental bundle 1, tab 2. Page 15, the first substantive page, repays careful reading, and I'm going to take your lordships through it fairly slowly. Paragraph 1 identifies the field of the invention, which is obtaining lipid from the cell by lysing, raising the pH of the cell, and contacting with the salt, separation of the lipid. Paragraphs 2 and 3 reference the two CGK methods of lipid separation, both involving an organic solvent. So the traditional hexane process is described at paragraph 2. You remember that the hexane process avoids the emulsion problem by drying the cells first, so that you are lysing in the absence of water. And then paragraph 3 talks about separation using isopropanol. Here, isopropanol is referred to as isopropyl alcohol. That's essentially the free LX method. And here you'll remember the method involves, you get your emulsion, but you use isopropanol to break the emulsion. Then the problems with these processes are discussed at paragraph 4, and this is hopefully familiar stuff now. It describes the hazards of organic solvents, the difficulties in recovering the organic solvent, the costs that all of this imposes on the process, and so on. So that's paragraph 4. And then the goal of 801 is stated in clear terms at paragraph 5. Therefore, there is a need for a process for obtaining lipids from a cell which does not use an organic solvent. Paragraph 5 goes on to refer to some unsatisfactory attempts to solve this problem. The second of those two US patents, 7431952, that's part of the same family as Beal, and we know that Beal doesn't work. So paragraph 5 concludes by saying, thus, what is needed is a process that does not utilise a volatile solvent to extract a lipid from a cell, and which can be performed using readily available equipment and a minimum number of steps to provide a highly pure lipid. 6 refers to another bit of prior art, and then 7 says that the invention is a process comprising, and then it sets out the steps of the granted claim. So the invention of 801 is a process for obtaining a lipid from microbial cells without using an organic solvent to extract the lipid. More detail about the process is given in the remaining parts of the specification, but it's convenient to look first at the claim. So we are looking at claim 1A, which is at paragraph 122, page 122. So this is essentially paragraph 7, which we looked at, plus a requirement that the lysis method is enzymatic lysis. So some comments about this. It's a claim to a process. First, at step A, the cells are lysed, and the end of the claim provides that this is done by enzymatic means. Then after lysis, the resulting emulsion is broken. It's demulsified. You see the word demulsify in steps B and C. So it's the combination of steps B and C which demulsify the emulsion. Step B involves raising the pH, and that's combined with one or more of the steps at C. Now, your lordships will see immediately that steps C1 to C3 were all methods that were known to be useful in seeking to break an emulsion. They were all CGK. Whereas step B and its associated step C4, they're wholly new in that regard. Then, because of the demulsification steps B and C, they enable the lipid to be separated out, which is step D. Claim 1A also provides at the end that the lipid contains less than 5% by weight of organic solvent. Now, we say that means that the whole process is substantially solventless. The judge construed claim 1A to allow for unlimited amounts of solvent to be used, just so long as the solvent is removed at the end. And that's the construction issue under our ground 1A. But you see there the words that your lordships have to construe. I'll come to ground 1A, but there is no dispute that this process, as a solventless process, works. It finally provided a method of obtaining microbial oil without the need for organic solvents. And that question was actually explored in evidence because Mara disputed that the process of claim 1A worked. They disputed that raising the pH to 8 could contribute to demulsification. And they said that even if it did work, it was not rendered plausible by the specification. But after the evidence, they abandoned all such attacks. They accepted that it worked, and they accepted that they themselves had used the process without solvents on an industrial scale. I should mention two other parts of the specification at this stage. So back on page 21, bundle page 21. Paragraph 86 provides an overview of the whole process. And I'll need to look at this in some detail on ground 1A, but just to summarise now, it specifies that a maximum of 5% organic solvents may be used at any stage in the process. Then,
You mean that's a summary of what it says?
I'm summarising paragraph 86, and I'm going to show you 86 in detail, but it's more convenient to do under a heading of ground 1A. Because essentially, we say paragraph 86 tells the skilled person how to understand the claim and indeed the whole invention. Then the other bit I want to just draw to your attention is the section beginning 108, paragraph 108, on page 24 of the bundle. This is a section headed Processes. And in this section...
Which page?
Bundle page 24. If I may, my lord, I'll always refer to the bundle pages.
Yes.
Bundle page 24. The heading at the bottom of the page, Processes. And what I'm going to show you is that you can see each step of the claimed process described with the various options and alternatives. And I do mean alternatives, so it includes alternatives that are not claimed. So can I just identify where each of the steps is? Step A is at paragraph 108. The process of the present invention comprises lysing a cell or cell biomass. And the paragraph gives options, including chemical, enzymatic, and physical lysis. Paragraphs 114 and 115 relate to chemical lysis. And the reason why I'm drawing that to your attention is because in our appeal skeleton argument, we mistakenly said that 115 is relevant to step B. That was an error, and I apologise for that. Enzymatic lysis, which is incorporated into claim 1A, is at paragraph 117. Then demulsification is introduced at paragraph 119. So you see line 5, demulsify and emulsify cell composition. Demulsification, you remember, is the subject of steps B and C. So step B is at 1, 2, 3. The process of the invention comprises raising the pH of the live cell composition to demulsify the live cell composition. The options for pH values are given at paragraph 126. And it's from here that we get the requirement of pH 8 or above in claim 1A, which your lordships would have to construe under ground 2. So 126 is the correct paragraph for step B. The judge did not make the mistake that we made in our appeal skeleton. He correctly recognised 126 as the correct paragraph for step B. Just for reference, that's judgment 725. Just for completeness, I just tell you where the remaining steps are to be found. So step C1, salt, is at 129. Step C2, heating, is at 133. Step C3, agitating, is in 139. It comes in the last sentence. Where am I? 139. Then step C4 is at 152. Step C is about adding a second base if the pH drops during the process, and that's what 152 says. And then step D, separation, is at 154. Okay. So with that introduction to the 801 patent, I need to show your lordships the Kobzev prior art. And this will be familiar because the Kobzev prior art is very, very similar to the 155 patent. So, so if you've got tab 4 of the first supplementary bundle, it starts at 131. So the invention is summarised at paragraph 2. It's directed to high quality lipids, and methods are provided which include the step of enzymatic treatment. The downsides of existing methods of extracting lipids from a biomass are at paragraph 4. But please note, Kobzev never claims to address the issues with polar organic solvents. At paragraph 111, there is a statement that the method is conducted in the substantial absence of an extraction solvent. Now, paragraph 11. Substantial absence of an extraction solvent. Now, it's common ground that this was a reference to a solvent which dissolves the oil, like hexane. It's not talking about the sort of solvent used in the Free-Lex process. This is recorded in the judgment in 819. And indeed, consistent with that, Kobzev does use a polar organic solvent to extract the oil. So, another way of putting the point is to say that in the background, Kobzev does claim to be able to do away with hexane, but does not claim to be able to do away with a polar organic solvent such as isopropanol. The benefits of using enzymes for lysis are explained at paragraphs 14 to 16. And the first sentence of 16 is heavily relied on by my learned friend. In fact, he showed it to you in 155. The use of a protease enzyme can help break down emulsion stabilizing proteins present, thereby aiding the breaking of an emulsion. So I'll be addressing this. But the point I want to make now is that when it lists the benefits of using enzymes, when it lists the benefits of its invention, it does so in 14 to 16, and it does not identify avoiding the use of an organic solvent as one of its benefits. It does not suggest that that's something that you get out of this. Details of which enzymes to use and their methods of action are given at 22 to 23. Nothing turns on them. Then at 24 to 31 contains an outline of a process. And use, again, this is a passage which you saw in 155. And it does say at 29, if the lipid from the above step is in form of the emulsion, and I just add here, which of course it would be, this product can be used as is, or dried and used. So just pausing there. you couldn't feed that to humans, but there was evidence that you could, at this stage, just take the biomass and feed it to animals. They don't mind eating algae, and they get the health benefits of the oil, but not to humans. But nothing turns on that. Then it says, or treated to release the lipid from the emulsion. So that's what is important for this case. And then it says treatment can include treatment with polar organic solvent, salt, precipitating agent, and other enzyme protease of another kind, heating, cooling, etc. Now, 3 points to note about this passage. First, there's no disclosure of a solventless process in this passage. There's merely disclosure of treatments, a list of treatments which included the first one, polar organic solvents. So, for example, heating is disclosed, but there's nothing to suggest, and no one made the suggestion, that heating alone, without also using a polar organic solvent, could work to break an emulsion. Second, this passage, when read with the CGK, would put the skilled team in mind of a whole host of different treatments and combinations. You can add, this is missing a couple of examples from 656, but there are a whole load of things that you could come up with out of this. But thirdly, this is important, the only treatment actually demonstrated to work in COBSEF is the combination of polar organic solvent, isopropanol, and centrifuging. That's example 3. The next paragraph I should, so there's some more text, and although I'm not taking you to it, there is more text before you get to paragraph 36, which describes 3 options for separating lipids after lysis. The first option, in the first sentence, is separation by centrifugation or other appropriate methods. Now, I'm going to show you the evidence about what the skilled person would think of that in due course. They'd be sceptical. The second option in 36 of COBSEF refers to the use of an alcohol or other polar organic solvent, so i.e. a free Elex process. And then the third option refers to the use of a solvent that will dissolve the lipid and refers to solvent extraction, so that's hexane extraction. Then you have the 3 examples from 39, which you've looked at in the context of 155. My learned friend correctly pointed out that examples 1 and 2 are irrelevant for present purposes because they don't involve the separation step. And example 3 does, and just to point to you the points that he pointed out, alkalase is used to lyse the cells at 53, and then at 55 to 7, isopropanol is used as a polar organic solvent together with centrifugation to separate the oil from the water and cell debris. So this is essentially the free Elex method, but with enzymatic lysis. And of course, the use of a polar organic solvent is of course consistent with the CGK as to what would in fact be required to break a microbial oil emulsion. Now, this is important. These 3 examples are sufficient to show the reader the effectiveness of COBSEF's advance, i.e. the enzymatic lysis of schizocutrium cells, as opposed to usual mechanical means, works and produces a high-quality oil. COBSEF doesn't attempt to go beyond that. It does not explore what other aspects of the normal process for making single-cell oils could be altered. So now I need to turn to the judge's judgment on obviousness over COBSEF. So I'm in the core bundle at tab 12, page 301. So the heading, you see alleged obviousness over COBSEF above page 851. So at 851, he's implicitly referring back to his section where he's rejected the allegation of anticipation. And he says that on his interpretation, COBSEF of claim 1A, 801 is obvious over COBSEF. So that's predicated on his construction of claim 1A, which allows for the use of unlimited amounts of organic solvents. So we challenge that construction and therefore 851 under our ground 1A. The judge went on to consider the other arguments And the way this works is that starting at 852, under the heading Mara's contentions, the judge recited Mara's case on Kobzev. This section is cut and pasted from Mara's written closing. Then starting at 869, under the heading DSM's contentions, the judge recited DSM's submissions, cut and pasted from our written closing. And then what he did is after each submission of ours, he then gave his decision on that submission. So starting, if I can just point you to the relevant bits of Mara's contentions, there was no dispute that Kobzev disclosed step A, enzymatic lysis. Step B, the pH raise, is addressed at 856 to 862. Kobzev suggests using alkalis to lyse the cells, and it would be obvious to do that at a pH of 8 or above, and we don't dispute that. The key passage for the purpose of this appeal is 864 to 865, but 863 to 865. In 864, Mara submitted that Mr. Dupin agreed that it would be obvious to use salt and or heat without any polar organic solvent. And in 865, Mara submitted in the alternative, it would be obvious to adapt Kobzev's suggestion of using an organic polar solvent such as isonipropanol to break the emulsion in a free-lex approach in combination with stirring. That's a reference to example 3. And this was within the claims on the judge's construction of less than 5% organic solvent. So that's the same construction point that underpins the judge's 851. So then starting at 869, the judge set out DSM's contentions in his ruling. The first contention is at 870, that Kobzev did not make it obvious to do the pH rise after lysis, as required by step B. The judge rejected that at 871 to 872, and we don't appeal that point. Then the second contention at 873 was that Kobzev taught the use of polar organic solvent to demulsify. The judge rejected that because he construed claim 1A as covering a process which uses an unlimited amount of organic solvent. So we challenged that under ground 1A. And then the third point, our third contention, 875, was that it was not obvious from Kobzev to move to a fully solventless process. And we cited Mr. Dupin's written and oral evidence to that effect. The judge dealt with our third contention at 877. However, these examples only work on DSM's construction of the less than 5% integer, which I've rejected. Development of a solventless method is not required. Then at 878, the judge said, for all these reasons, I find all the claims of 801 were obvious over Kobzev. Now, in relation to the integer requiring less than 5% organic solvent, the only reason given by the judge, which this sentence could refer to, was the construction point. That's the only reason he had given for rejecting our third contention. And after that, he said, I accept Mara's submissions as recorded in 855 to 868 above. Now, literally, that sentence encompasses both the alternatives recorded at 864 to 865 that I showed you. But 877, and especially the first sentence of 878, strongly implied that he was only actually accepting the construction point, the point in 865. That's certainly how we read it, albeit we saw the ambiguity and we sought confirmation of that reading at the form of order hearing. And the judge's response to that is in the bundles, and your lordships need to look at that. It's in the second supplemental bundle, tab 25 at the very end. So 123 records the fact that I raised the point. And at 124, the judge said, faced with this argument, I reviewed carefully this section of the main judgment, and in particular the transcript references relied upon by Mara and recorded in 864 and 865. So that's what he reviewed. As indicated in 851, I was dealing with other arguments, assuming I was wrong on any of the construction issues on the disclosure of Kobzev. The transcript reference in 864 appears to be correct, and if we go on to the end of 298, I consider this an evaluative conclusion, having heard Mr. Dupin giving evidence Having considered DSM's arguments, I meant what I said in 878, by which we read the second sentence of 878. This was 8 months after the trial, so he's simply going off the transcript references cited by Mara, and he did not, according to this, take into account in his rereading any of the other written or oral evidence or oral submissions from trial. Nevertheless, the upshot is that we have to challenge the acceptance of the submission recorded at 864, and that's our ground 1B. So I've identified what grounds 1A and 1B are, and obviously we need to succeed on both to overturn the finding of invalidity. So I'm going to start with ground 1A, that the judge was wrong to construe claim 1A as including a process which used more than 5% organic solvent, as, for example, Kobsev example 3 does. Our overall submission on this is that on this construction issue, the description makes it clear beyond doubt what the claimed invention is. And so it's worth mentioning the principle, which is now unanimously applied in the English courts, the EPO and the UPC, that the description should always be taken into account when construing the claims.
You shouldn't assume that everybody in court knows what the UPC is.
Yes, sorry, my lord's quite right. So the principle that I'm going to cite is unanimously applied in these courts, in the European Patent Office when they're having to construe claims, and in the Unified Patent Court, which applies the same substantive law as this court does when considering construction of claims, when considering patents having effect throughout a certain part of the EU. And the principle is that the description should always be taken into account when construing the claims, and not only used when there is some ambiguity in the claims. And my lord, if it's helpful, I can give you one reference from each of those jurisdictions. I'll just tell you where they are. They're in the authorities bundle. So English law, you find it in the decision of this court in Saab CI at paragraph 18, sub paragraph 4. The European Patent Office decision of the enlarged Board of Appeal in G1 of 24 at paragraph 18. And in the Unified Patent Court, the UPC Court of Appeal in 10x Genomics and Nanostring at page 24 of the judgment, and all of those are in the authorities bundle. I'm not going to them because this is an uncontroversial principle, but it's strongly engaged on the facts of this case. So, if I may take your lordships back to the patent, which is in Sup 1 bundle, and start at page 122 the bundle. The words your lordships are construing are wherein the lipid contains less than 5% by weight of an organic solvent. Now, we accept that if you read this claim without reading the rest of the specification and without knowing anything about microbial oil production, you could think that this was referring only to the end product. However, claim 1A is a claim to a process, and these words are a characterizing feature of the process. And if you read the words as a characterizing feature of the process, they mean that throughout the process there is less than 5% of organic solvent by weight of lipid. And when you read the words in the context of the specification in the CGK, it's absolutely clear that the patentee intended that second meaning. Now, I've already shown you paragraphs 1 to 7 of the specification, which make absolutely clear that this patent is addressing the problems with organic solvents and putting forward a solution which does not use an organic solvent. A process which uses unlimited organic solvents is anathema to this patent, and it would be perverse to read that summary and then conclude that the patentee intended to claim a process which used unlimited amounts of organic solvents. The point is strongly reinforced, and the words in claim 1A explained, by that paragraph 86, which I promised to come back to. So if I may, I'm going to take you through paragraph 86 quite slowly. So the first sentence says, generally, the processes of the present invention do not utilise an organic solvent in order to extract or otherwise separate a lipid. Obviously, the word generally means that this sentence is not good enough for my purposes, because it's a qualified statement. The second sentence says, thus in some embodiments, an organic solvent is not added to a cell broth comprising plant material or fermentation broth comprising a microbial cell, is not added to a cell composition, is not added to a lysed cell composition, or is not added to a lipid during a process of the present invention in an amount or concentration sufficient to extract a lipid. Now again, that sentence isn't good enough for my purposes because it says in some embodiments. But note how it's talking to every stage of the process. It's talking about the fermentation broth before lysis, the cell composition before lysis, the cell composition after lysis, and it's saying not for the purposes of extraction. Then the third sentence says that some organic solvents can be added. And again, that third sentence refers to every stage of the process. Then the next sentence, which begins on line 4, says, in such embodiments, the organic solvent is added in a concentration less than 5%, 4, 3, 2, 1%, 0.5%, 0.1%, or less than 0.5% by volume. So that sentence is saying that if any organic solvent is added, at any stage of the process, it's added to 5% maximum. That sentence is unqualified, my lords. So never more than 5%. Lines 8 to 12.
5% of what?
Can I come back to that? I'm going to address that.
Okay.
It says there by volume. I'll answer it now. It says there by volume. Later it says by volume or weight, and it becomes clear that they're talking about by volume or weight of the lipid. But let me come back.
But volume, just on that sentence, if you're doing it sentence by sentence.
Yes.
The obvious referent for that is 5%. I would suggest is 5% by volume of the cell composition, or lysed cell composition, or demulsified cell composition, because those are the things referred to in the previous sentence.
Yes, I see that. Once we read the whole paragraph, it will become more clearer. But
Thank you.
I don't disagree that just focusing on that sentence at this stage. I see why you say that. Lines 8 to 12 provide some definitions, and just note that both hexane and isopropanol are identified as organic solvents. And then we pick it up again at line 13. No, that doesn't look right. Yeah, 15. Yeah. Is it 15? Oh yes, sorry. No, it is 13. An organic solvent as defined here can optionally be added to a lye cell composition. For example, as a component of a base or a salt for contacting with a lye cell composition. So what that's saying is that we're not ruling out any single drop of organic solvent, because you might want to have it, if you're adding a salt, for example, you might want to have the salt, have that as a component of the salt. However, this is important, line 15, in such embodiment...
I don't understand that as a matter of chemistry. How on earth is an organic solvent a component of a salt?
I suggest the answer...
Seems to be counterintuitive, to put it mildly.
My lord, I suggest the answer is that what the patentee is doing here, I'm foreshadowing a submission I was going to... What the patentee is doing here is saying, this is a solventless process. But I'm just going to make sure that if you add a little bit of solvent, you can't escape my patent, because I can just about foresee people might want to add a tiny little bit, maybe to take advantage of my invention without strictly infringing it. So I'm absolutely sure what your lordship has said is correct as a matter of chemistry, but the sense of it that you get from the whole is you might want to add a little bit of solvent somewhere here for some other purpose, but not for extraction. And there's a strong message in this paragraph stated twice that you're not to use the solvent for extracting the lipid. So if I may continue, however, in such embodiments, so that's in any case, I'm sorry, I'm on line 15. However, in such embodiments, i.e. any case in which you're adding a bit of organic solvent, the organic solvent is present in a concentration such that the lipid is not substantially extracted from the cell composition, live cell composition, or demulsified cell composition by the solvent, i.e. in a concentration less than all those amounts by volume or weight. Now, as my lord pointed out, this sentence also is not explicit as to what volume or weight the percentage is referring to. We would suggest that the best reading of lines 16 to 17 is that it's talking about volume or weight of the lipid, but claim 1A clearly specifies percentage weight of the lipid. And the important thing is that this sentence beginning on line 15 is explicitly addressing each and every stage of the process, not merely the end result. So the patentee could not be clearer that the process is not allowed to involve more than 5% organic solvent at any stage. Yet the judge's construction totally contradicts this passage. However this passage is read, the judge's construction allows unlimited organic solvent to be used. And it allows as much organic solvent to be used as you like to extract the lipid, which is the thing that's specifically prohibited, just so long as the solvent is removed right at the end of the process. Now, 801 includes a number of examples. And can I take you to those? They start on page 40 of the bundle. And examples 1 to 20 are examples of the process, and none of them use any organic solvent in the extraction process. I skip over examples 21 and 22 because they do not concern microbial extraction, oil extraction. And then examples 23 to 27, they use hexane extraction or Freelex as a comparator with one of the previous examples. So if I can show you example 25, for example. So I'm on page 49 of the bundle, paragraph 244. And you can see from the first sentence of 244 that crude lipids were obtained using the process of example 16, i.e. no organic solvent whatsoever. And then it says additional lipids were obtained using the Freelex process, which uses isopropanol to extract the oil from the lysed cell composition. And the results are compared in table 7. And the conclusion at the end of 245 is that the comparison data demonstrates that the extraction yield of lipids obtained by the process of the present invention is superior compared to the extraction yield of lipids obtained by the Freelex process. Now, in Mara's skeleton argument, they rely on paragraph 52 and some similar paragraphs. So paragraph 52 is on page 18. So does your lordship have page 52, paragraph 52?
Yes.
Now that paragraph does appear to be about the end product and about the solvent content of the end product.
Can you just help us with the typography? Because two sentences seem to have been run together. Do I take it that we read this as having a full stop and a space between the word oil and the word the.
That's certainly one way of doing it, yes. I think that's probably the best way of doing it.
Thank you.
As I say, this paragraph does appear to be about the end product and the solvent content of the end product. For what it's worth, we don't agree that all the paragraphs that they cite are about the end product, but this one is. And we make 3 points about this paragraph and the other ones that are relevant on this point. First, there's no inconsistency between this paragraph and the paragraphs I've shown you or my construction of Claim 1A. The skilled person would understand that the reason the end product has less than 5% organic solvent is because less than 5% organic solvent is used in the entire process, as the patent teaches repeatedly. Secondly, this paragraph 52 is just an optional feature in a long list of optional features. So if you look, for example, at the previous paragraph 51 or 50, they fall into the same category. None of these are part of Claim 1, or indeed any claim of the patent. And indeed, it's a feature of this patent that there are lots and lots and lots of things which are said to be possibilities that are not in any of the claims. But one thing which is not said to be a possibility is adding more than 5% organic solvent at any stage. So but the contrast is between a paragraph like 52 with an option and paragraph 86 of the patent under the heading Overview, which is giving the skilled person the unifying feature of the invention. 86 is giving you the core of the invention, whereas this paragraph is just an optional feature. Third, paragraph 52 really is pure boilerplate. Let me explain what I mean by that. The skilled person knows that in a process that involves any organic solvent, all the organic solvent must be removed at the end of the process. The judge made that finding at paragraph 132. Indeed, my learned friend makes it in his skeleton argument, paragraph 30, that all the organic solvent needs to be removed at the end as a matter of CGK. So, on Mara's construction, the patentee has included in Claim 1 a feature which just goes without saying, while omitting the absolute essence of the invention. And that's just not how the skilled person would read it. My lord, there was relevant expert evidence on this topic too. And what I'm going to show your lordships is technical evidence going to the technical teach of the patent. It's not merely experts opining on the meaning of words. Paragraph 86 in particular is technical teaching on which expert evidence is relevant. So first, Mr. Dupin. So that's Supplemental Bundle 1, Tab 7, page 218. Paragraph 183.
Yes.
Mr. Dupin could not see why a small amount of solvent was permitted, but our skilled person who knows a little bit of patent law would know that if the patentee had specified 0 organic solvent, it would have been too easy to avoid infringement while still taking advantage of the invention. That was the point that I was trying to make in answer to my lord's question. Then Dr. Kyle in tab 9, page 320 of the bundle, talks about paragraph 86 at his paragraph 346. he says at the end, in context, the skilled person would have understood the term less than 5% organic solvent to describe a primarily aqueous extraction process. However, that would be inherent in the description of the remainder of the process. So he thinks an aqueous process is inherent in the process of the patent, which we certainly agree with. And just by way of illustration, if you go to page 338 of this bundle, at page 418, Dr. Kyle is considering the issue of infringement by Mara's process. And he says, 418, the first thing I've noticed is that Mara uses an aqueous extraction process for all of the processes in question. And I understand that Mara admits that it does not use an organic solvent in the process of extraction, i.e. feature E in the table above is present in the Mara processes. Feature E is the feature that we are considering. So he equates this feature of the claim with an aqueous extraction process which does not use an organic solvent in the process. And what he does not say is, yes, Mara infringes because its end product contains no solvent. And at the very least, this evidence shows that our reading is a tenable reading of the wording of the claims. I say that because I expect Mr. Speck is going to say that these words of the claim are unambiguous and they can only mean what he says, but that submission just simply doesn't work in light of this evidence. My Lords, Dr. Kyle also gave relevant oral evidence on the technical teaching of the patent. That's in the second supplemental bundle, page 480, tab 20, page 480. And on page 480, it's if your Lordships could read page 803, line 12, to the very top of 805. Just the yes on the top of 805. Again, that's technical evidence. My Lord, those are our submissions on ground 1A. I need to just deal briefly with a point that's going to come against me from the respondent's notice. My learned friend says in point 1 of his respondent's notice that framing the integer by reference to weight of lipid only makes sense in respect of the end result. Now, we don't understand why there's any difficulty in comparing the amount of lipid with the amount of solvent added to see if the integer is satisfied. There was no evidence that the amount of lipid recovered in a process is so unpredictable that this issue would cause the skilled person the slightest concern. Moreover, the patent actually expressly contemplates that the skilled person can ascertain the amount of lipid present in the unseparated composition. That's paragraphs 167 and 168 of the patent. Page 33 of the supplemental bundle. (167) and 168 are talking about something different. They're talking about the lipid concentration of the composition. The broth or the lye cell composition. Sorry, apologies, I'm going to. So 167 is about the lipid concentration of the broth, and 168 is about the lipid concentration of the cell composition or lye cell composition. And the point is simply these paragraphs assume that you're able to ascertain the amount of lipid in the broth or in the composition, and nobody suggested that there was any difficulty in ascertaining the amount of lipid prior to the end. So there's just no problem with.
Well, you may be correct to say that those paragraphs assume you can do it, but does it explain anywhere how you can do it?
No, it doesn't. I mean, an obvious way would be just to simply take a sample and test it. But it is my learned friend who's
Test
making.
it how? That's the question.
Well, I put it this: the way I'm deploying the point is just simply this. My learned friend is saying that there's some sort of problem with making specification of the lipid during the whole of the process. And my first point is simply there's no difficulty. You know the amount of lipid at the end. And my second point is that the patent assumes that it's possible to do that, and nobody, as a matter of evidence, put forward a suggestion that there is any difficulty with these passages or any other passage. It was not put forward as a point of fact that there is any difficulty in doing this.
Right. So to summarise, as I understand it, you say these paragraphs assume you can do it, and you say there's no expert evidence that you can't do it.
Indeed.
Do you have anything to say about the word that the lipid contains less than 5% the weight of the organic solvent?
Yes. So my friend had a point in his respondent's notice about different phases, and I understand that's his respondent's notice point 2, and I understand that he's not advancing that point on the basis. Or rather, that point only arises if I run an argument that I'm not running. So he's not making a point about phases. When you use either the Frelex process or the hexane process, this organic solvent is fully mixed up with the rest of the composition. You see that, for example, in Kobzev when it explains how you add the isopropanol and you mix it up, and then you do the separation. There's nothing wrong with using the word "contain" in that context, where they're mixed in. I mean, in the case of a polar organic solvent, one isn't dissolved in the other, and even in the case of hexane, the lipid doesn't contain the solvent. The hexane dissolves the lipid. So, contain is clearly not being used in a technical. In a sort of physics sense of one being inside the other.
But that might be said to be suggestive that you need something like some oil, which you then could test in some way, and you discover that less than 5% of it was a solvent. It's not so. The words are the lipid contains less than 5% by weight. It's not clear to me what you're saying contains the solvent if it's not the oil itself.
Well, all I was saying is it's not contain in a very precise technical sense, in the way that, for example,
so your starting point is that as a matter of chemistry, if you read it literally, it's impossible.
Either way.
Because a lipid cannot dissolve a solvent. It's the other way around.
Indeed, and that applies to both constructions.
Yeah.
So it's not a point against my construction in favour of his construction. It's a point of inapt language on any view. Is the point my lord? If I've understood my lord's point, which was the point I was endeavouring.
If you're trying to read it in a chemical sense,
indeed.
Whereas the question then is, well, if you're reading it in a quantitation sense,
yes.
Then what does it mean?
Yes, it just means that in your mixture with your lipid, you've got less than 5% at any stage. Sorry, let me start again. I'm invoking paragraph 86, which refers to all these stages, and it's saying that at any of these stages in your mixture, the amount of organic solvent contained in that is less than 5% of the lipid.
The argument against you is why doesn't it say we're in the mixture contains less than 5%?
Indeed. Well, let's be frank, my lord. If I was drafting this claim, I would use different words, but that is true of probably every patent that I've ever litigated in my entire life, and no doubt many that others in this room have litigated. But happily, for this patent, unlike other patents, if you read the specification, you can be in no doubt what the invention is and what the patentee is trying to say that they are covering, and more importantly, what they say repeatedly they are not covering. And so that's why there's no difficulty in reading it the way I suggest. Yeah, is that right? Okay. Yes. So, my lord, you asked me, you said to me, you put to me, and I accepted, that paragraphs 167 and 168 assume that you could ascertain the amount of lipid in a composition. And I'm reminded that example 31 is a worked example of how to do that.
Where do we find that?
So that's page 55.
The measurement.
So 270 says oils are extracted from a biomass sample. So they extract the oil, and then at 271 they do flash chromatography to analyse the lipid itself.
It's been extracted by X.
273. 273 is about analysing the samples of biomass and isolated lipid classes were analysed. And table 16 is showing you the percentage of each lipid class in the first column, percentage of each lipid class in the biomass.
Sorry, I'm going to have to explain that a little more.
Yeah, so sample table 16 is an analysis of the biomass. So just to take the first row, fatty acid C12:0. That's a fatty acid with 12 carbons, and that's a fully saturated. That'll be fully saturated. And what that tells you is that in the biomass, there is 0.6 milligrams per gram of 0.6 milligrams of that particular fatty acid per gram of the biomass. So you're analysing the biomass, the individual fatty acids in the biomass.
Isn't that done after the process has happened?
Well,
you do all of the process. You get a load of crude oil out of it, and then you compare that to the weight of the biomass.
Well, this is...
Isn't that what that table does, or have I misunderstood that?
Well, we read this as oils were extracted from biomass samples. So you take a sample of the biomass and analyse it at that stage. So you're taking a sample out of the biomass.
But the description seems to be that you've isolated the lipids and then you analyse them using various scientific techniques.
Yeah, but
and then you can produce this table.
Yeah, I mean, to work out the mass of lipid, you always have to extract the lipid. The point goes no further than this. This appears to be taking a sample from the big biomass and testing that sample. So it's possible to just as I say, no one's ever said this is any difficulty. But if you wanted to analyse the amount, work out the amount of whatever in the biomass, you can just take a sample out of it and test how much lipid is in there, how much organic solvent is there. Is it less than 5%? I perhaps am over-engineering the submission, which should be as simple as
what I'm struggling
you can do
to
sampling.
understand is, I take the point that we've got absolute measurements in Table 16 and we've got percentages in Table 17, but where do we find the measurements of organic solvent?
No, this is, well, you won't, because none of the processes in the patent use organic solvents at all, so they wouldn't measure for them at all. It was, as I say, I might have over-engineered the submission. The submission is as simple as you can take a sample out of your biomass and then separate it out to work out how much lipid is in it and how much solvent is in it if you want to work out the amount of solvent at that stage. It's just simply in response to that. But you won't, in this patent, you won't find any measuring organic solvent. You won't find an example where it says, here, look, there's only 2% organic solvent, because they never use a drop of organic solvent in the extraction process.
Yeah.
That's,
and of course, 167 and 168 are not about using organic solvent.
no, indeed, they're not. They're not. But they just proceed on the basis that you can ascertain the amount of lipid. And I use ascertain deliberately, whether it might be by estimation or by taking a sample. It can be ascertained, and no one said there was any difficulty in ascertaining it. None of that, of course, detracts from my main points, which I obviously led with. But that's where I finish on ground 1A. That was just for completeness. So I'm going to move on to ground 1B, unless you want any questions on that. So ground 1B is essentially that the judge was wrong to accept the submission, which he recorded at 864 of his judgment, that it was obvious to pursue a solventless process in light of COBZEF. And obviously, for this purpose, I assume that I succeeded on ground 1A. So just to tell you where I'm going with this, we essentially have three overall submissions, which I will make good. First, there was no evidence to support a finding of obviousness. Second, in the alternative to the first submission, the judge failed to carry out the necessary analysis of obviousness, so it falls to this court to do so. And third, and in any event, on the evidence that is available, the only rational conclusion is that 801 is not obvious. There is a big difference between this appeal and Mara's appeal on 155. On 155, we've seen careful analysis and evaluation of the evidence by the judge, whereas we see nothing of that sort in relation to that point. Now, because my primary case is that there was no evidence that Claim 1A is obvious, I need to show you some reports and transcripts to show you that the evidence isn't there. At least we only have to consider Mr. Dupin's evidence, because Mara accepted that it couldn't rely on Dr. Carr's evidence on whether 801 was obvious, and the judge agreed that they couldn't rely on Dr. Carr's evidence. So I start with Mr. Dupin's written evidence. My lord, the key evidence was set out by the judge in the judgment, but I'll show it to you in the report to give you a little bit more context. So I'm in the supplemental bundle, tab 7. Starting on page 212. So I'm just showing you this for context. Paragraphs 155 to 156 just set up the point. Under the heading, The Skilled Bioprocessing Engineer's Approach to COBZEF. The bioprocessing engineer, of course, is the downstream member of the team. And then on to page 227, pages 226, sorry, paragraphs 226 to 228. So that is cogent evidence directed at the correct target, giving valid reasons. Now, Mr. Dupin specifically addressed the concept of centrifugation as a means of demulsifying, which we saw referred to in paragraph 36 of COBSEF. So I should show you that. That's in the next tab, page 240, at paragraph 37.
Sorry, which page?
Page 240, paragraph 37. And he's addressing the use of centrifugation as a means of demulsifying. So again, that's measured evidence explaining how centrifuging alone can work for weak emulsions such as olive oil and water, but the skilled team would understood that for microbial oil production, the emulsions are simply too strong to break by centrifugation alone. Now, the judge referred to this evidence without reservation at paragraph 664, and the judge specifically made the point that Mr. Dupin maintained that position in cross-examination. That 664 is page 269. Now, since Mara could not rely on Dr. Kyle's evidence, they could only succeed on this point at trial if they got Mr. Dupin to resile from the written evidence I've shown you and say that in fact claim 1A of the patent was obvious. So I turn to the cross-examination again to show you what is not there. So now I'm in the second supplemental bundle at tab 16, page 440. This section is too long for me to take you through it line by line. I'll just show you where the relevant things would be if they were anywhere in this cross-examination. So to orient you, you can see it page 240 in the manuscript, line 17. Mr. Speck turns to COBSEF. And the first relevant topic for our purposes is paragraph 16 of COBSEF. And the questions on this paragraph are at 252, line 24 to 253, line 8. And the thing which isn't there is that it was not suggested to Mr. Dupin, and he did not say that paragraph 16 of COBSEF would motivate the skilled team to investigate solventless extraction. Indeed, it's worth mentioning that not even Dr. Kyle said that paragraph 16 would motivate the skilled team to investigate solventless extraction. Then, going ahead to page 262 of the manuscript, at line 13, you can see that Mr. Speck is cross-examining about the passage in COBSEF that begins with paragraph 24. You remember that paragraph 24 to 30 included various possible treatments for the emulsion. And the discussion about these paragraphs continued all the way to 266, line 2, Now, Mr. Speck did not rely on any of this at trial, and he doesn't rely on any of it in this court on the question of obviousness of a solventless process. The only bit of potential relevance is 265.14 to 266.4. At 265.14 to 266.4, Mr. Dupin made the point that the skilled person would not know whether any of the various possible methods for breaking an emulsion would work for the emulsion in COBSEF. Then the next bit is at starts at 268, line 20. Here Mr. Speck is asking Mr. Dupin about paragraph 36. And this passage goes on to 271, line 13. And again, Mr. Speck does not rely on this passage. And the point I make is that nowhere did Mr. Speck put to Mr. Dupin that it would be obvious from paragraph 36 to develop a process that did not use a solvent at all. The passage that Mr. Speck relies on, and which the judge referred to, is on page 454 of the bundle. May I ask you to read page 296, line 1 to 298, line 13, and then I'll make my submissions, please. My Lord, you can see on this page that Mr. Speck is synthesising paragraphs 30 and 36 of COBSEF. If you just run through it, you can see he starts off from 296, line 4 about paragraph 30. He then goes to 36, then back to 30, back to 36, back to 30, back to 36, then back to 30. You can track that through. There was no suggestion that the skilled team would synthesise these two quite separate paragraphs in that way. Mr. Speck did not ask, Mr. Dupin did not say that the skilled team would read COBSEF like this. More importantly, Mr. Speck did not suggest to the witness, and the witness did not say, that it would be obvious to seek to develop a solventless process from COBSEF. What you've got is at 296, line 14, Mr. Dupin making the point that the methods listed in COBSEF had been shown to work for other emulsions. And that's a point that runs through the judgment and his evidence. At 296, line 25, Mr. Dupin said that salt could break an emulsion. It's could and an emulsion because it depends on what the emulsion is, including how strong it is. At 297, lines 17 to 18, Mr. Dupin agreed with the suggestion made without context that it would be obvious to use a salt. Now, remember, it was CGK to use a salt alongside the free elex process. That's paragraph 128 of the judgment. And of course, both paragraphs 36 and paragraph 30 talk about using polar organic solvent. So absolutely, in a discussion about COBSEF generally, it would be obvious to use a salt. No question it would be obvious to use a salt, add a salt to example 3. But Mr. Speck did not put, and Mr. Dupin did not say, that it would be obvious to use a salt without also using a polar organic solvent in the context of COBSEF microbial oils. Nor, should I say for completeness, did Mr. Speck suggest to Mr. Dupin that if the skilled team did think of developing a solventless process from COBSEF, they would have any expectation of success. And Mr. Dupin's consistent evidence was firmly to the contrary. For example, 298, line 2 to 7, you just wouldn't know. My Lords, I'm conscious that I've shown this court more evidence that this court likes to be shown on an appeal, but you'll understand why I need to do that. A fair summary of this evidence would be as follows. Mr. Dupin said in writing that it would not be obvious to pursue a solventless process in light of COBSEF, with cogent reasons. Mr. Dupin specifically addressed the idea, which is mentioned in paragraph 36 of COBSEF, of doing separation by centrifuging without a solvent, and said the skilled person would believe that microbial emulsions were just too strong to break in that way. And none of that was challenged in cross-examination. It was not put that it would be obvious to pursue a solventless process in light of COBSEF. It was specifically, it was not put that paragraph 16 or 36 or anything else in COBSEF would motivate the skilled person to pursue a solventless process. And it was not put that those paragraphs or anything else in COBSEF would make the skilled person think that pursuing a solventless process would have any prospect of success. Mr. Dupin made clear his view was the opposite. So that's the absence of evidence point. I now need to address the judge's failures of analysis. And for that, I need the judgment. So the core bundle, tab 12, page 302. So I'm looking at paragraphs 863 to 865, and I'm treating these as the judge's finding, albeit he does reject some of 863. So 863, the first sentence, solventless extraction was of course a CGK interest. That's obviously true. The second sentence, paragraph 16 of COBSEF, also indicates that protease itself can help breaking an emulsion by breaking down emulsion stabilizing proteins, a suggestion that Mr. Dupin said can be trusted to be correct. That's true as far as it goes, but the evidence went no further. My learned friend wants you to make the leap from paragraph 16. My learned friend wants you to make the leap from paragraph 16 to the skilled person thinking, oh, maybe that means that a solventless process is worth trying. But that's not what paragraph 16 says. It doesn't say, therefore you can use a solventless process. On the contrary, COBSEF itself still uses isopropanol to break the emulsion, even having identified that point. It would require evidence to the effect that paragraph 16 would inspire that thought in the skilled person, and not one witness made that suggestion. And the judge did not make a finding that paragraph 16 would inspire that thought on the skilled person. As to the third sentence of 863, therefore, so Morris submitted use of an enzyme reduced the prospect of strong emulsion in two ways. First, much gentler stirring, which he said a point which is not accepted to be proved to be CGK. And secondly, the breakdown of emulsion stabilizing proteins tends to reduce an emulsion as well. My Lord, we think that my learned friend's summary of this sentence in his skeleton argument, paragraph 40, is incorrect. So just when you read his paragraph 40, which relates to this sentence, please make your own mind up about what it's saying. The important thing is what the third sentence of 863 does not say. 863 does not say that COBSEF or these thoughts would motivate the skilled team to pursue a solventless process. And I've made the point ad nauseam that there was no evidence to that effect. Then we come to 864 of the judgment. I've shown your lordships the cross-examination. This proposition simply was not put to Mr. Dupin Mr. Dupin just did not say this. The submission recorded in 864 was in Mara's written closing. As you know, this section is all cut and pasted. So I made detailed oral submissions on this written submission to the judge, as I have made to your lordships, which the judge does not appear to have considered at all. There's no sign of the judgment in the judgment of the judge considering those oral submissions or grappling with the totality of the evidence on this specific point. There's no evaluation of the sort with which this court is reluctant to interfere. The judge just copied and pasted our written submissions and then rejected them on the construction point. And as we've seen, when he reread the transcript references cited by Mara 8 months after trial, he did not consider the totality of the evidence or the totality of the submissions. That was the very last page of the supplemental 2 bundle. So the judge has made a number of identifiable errors of principle here. 1, there's just no analysis of the evidence. 2, no reasons why he's accepted the submission at 864 when we heavily disputed it at trial. There's no consideration whether the cross-examination relied on was hindsight-driven, step-by-step style cross-examination, or whether it properly reflected the thinking of an unimaginative skilled team without hindsight. There's no consideration of the expectation of success. There's no consideration of the skilled team's motivation. So I've made good my first submission on ground 1B, which was that there was in truth no evidence to support the finding of obviousness. And I've also made good my second submission in the alternative, which is that the judge failed to carry out the necessary analysis of obviousness. My third submission, which I've also made good in the process of those 2 submissions, is that on the evidence of Mr. Dupin, which was the only relevant evidence, as everyone accepts, the only rational conclusion is that 801 is not obvious. It's not obvious to pursue a solventless process in the light of COBSEF, which is just doesn't promise that or offer that at all. So, my lord, that's what we wanted to say on ground 1B.
So, just so as we're not in any doubt,
Yeah.
This is on the premise that you are successful on your ground 1A construction.
I have to succeed on both.
Yeah.
So 1B is it's not obvious to pursue a solventless process, which is what 864 is directed at.
Yeah, I understand.
Yeah.
I understand. It was clearly stated the Skinner's an argument.
Yes.
It's always nice to,
indeed.
to bring the point to mind during the course of oral argument.
No, indeed. My lord.
It's just a follow-up question.
Yes, of course.
On that. Then so supposing you win on ground 1A, you're then asking this court to substitute a conclusion on the facts, essentially, for that of the judge, partly on the basis that you say the judge didn't grapple with the evidence and the arguments.
Yes, that's a compressed summary of my slightly larger summary, which is 1, no evidence, which obviously if I'm right, then I win because the burden is on them to prove obviousness. Alternatively, failure of analysis. And then thirdly, which comes in if the second point arises, that once you look at Mr. Dupin's evidence, the only relevant evidence, the only rational conclusion is that the patent is not obvious. So those are the 3 submissions, and the third one can stand alone. But obviously, I say my primary case is that there's no evidence at all.
Yes, I say it's a conclusion on the facts, but what I really mean is to reach its own evaluation.
Yeah, absolutely. Absolutely, I have to, as Mr. Speck does on 155. I have to face up to the fact that on ground 1B, the judge has purported to make an evaluation, and I have to say that I have to ask you to interfere with that, and I understand what that means in this court, and that's why I put my submissions the way I do. I don't shrink from that.
But as I understand it, you do make the point that the judge's primary basis for rejecting the obviousness argument was his construction of the claim, and therefore when we get to ground 1B, we've only arrived there if he's wrong on his primary reason and we're here addressing a contingent finding.
I do accept that, and I accept that.
But it's a point in your favour, in a sense, if we get this far.
Yes, I see that. It can be. My learned friend will say, well, he dealt with it shortly because it was contingent. But he didn't deal with it at all properly. And if that was because it was contingent, then so be it. It doesn't really matter from my point of view. You're right. It is a point. It's an explanation for why he went wrong, because it was contingent.
Yeah.
My lords, so I'm now on ground 2, infringement. On infringement, there was no dispute that the majority of the processes that Mara had carried out infringed. There was a subclass of processes where the pH rise at step B was between 7.5 and 8.0. There he found on a construction point that they didn't infringe. I'm going to ask Ms. Nizami to address you on why he was wrong about that.
Right.
She thinks she'll be less than 15 minutes. No. She thinks she'll be about 15 minutes. We're really in your lordship's hands.
No, absolutely. Yes, please. Thank you. Yes.
My lords, the judge's construction of pH 8 or above in Claim 1A was that it meant exactly 8 or above. That's paragraph 790 of the judgment. DSM contends that was an unduly precise construction. Properly construed, pH 8 or above means a value that is pH 8 when expressed to 0 decimal places or above. The legal principles relevant to this issue are found in Smith & Nephew and Convatec. We provide a reference to that case at paragraph 42 of our skeleton. But the dispute on this appeal focuses on the application of those principles. We rely on 5 reasons in support of this ground of appeal. First, there is a convention amongst scientists that numerical values are understood as precise to the degree of precision with which they are expressed. That convention was explained by Lord Justice Kitchen, as he then was, in Convatec at paragraph 19. It has also been recognised in numerous cases before and after Convatec. Some examples are set out in our skeleton at paragraph 44. Another example is Knapp and Dr. Reddy's, in which my Lord Justice Arnold concluded, at first instance, that applying the usual scientific convention, 10% by weight buprenorphine meant more than or equal to 9.5% and less than 10.5%. That was upheld by the Court of Appeal, who referred to the convention as the normal rounding convention. What these authorities make clear is that while normal principles of construction apply to the interpretation of numerical values, the skilled team reads the claims in the context of the specification. They also read the claims using the conventions adopted by scientists, as Lord Justice Kitchen explained. DSM's construction of pH 8 or above in the claim is consistent with the normal rounding convention, whereas the judge's was not. My second point is that there's nothing in the specification of EP 801 which would convey to the skilled reader that the normal rounding convention was not being used. In contrast, there are cases in which the patentee makes clear that they're not using the normal rounding convention in the claim. Jushi is an example of that, in which 23% or higher in that claim was understood to be an exact number, because the specification contained a comparative example with a value of 22.88%, and the patent made clear that that was outside the scope of the claim. There's nothing to that effect in the present case. In fact, example 17 of the specification points in the opposite direction. May I show that to my lords? It's Sup 1 tab 2, page 45. Example 17 is at the top of the page. And lines 5 to 6 describe that this the lye cell composition was treated with a base until the lye cell composition reached a pH of 7.8 to 8.2. So this is an example in which the first pH raise, step B in the claim, was to a value at the lower end of the claimed range. It indicates that a strict cutoff at pH 8.0 is not necessary. And the judge accepted that example 17 provides such an indication. For my Lord's reference, that's judgment paragraph 785. So example 17 is...
Well, let's have a quick look
Yes.
at that.
So the first sentence, my Lord, records that I agree that pH values in example 17 can be taken as such an indication, and the indication being referred to is the one that I just gave and recorded at paragraph 784.
Okay, I'm a bit puzzled by that. So let's be clear. On your submission, example 17 is within the claim.
Subject to one qualification, my Lord, which is that I acknowledge that example 17 doesn't use enzymatic lysis. But what it teaches about the pH raise is within the claim, and it shows that the first pH raise to 7.8 to 8.2 worked. It records that a lipid is extracted. And I will, just for completeness, I note the second sentence of paragraph 785, and I will come back to address that point under my fifth reason. So example 17 in my submission is a positive...
Yeah, just before we get into that, so one of the points that's made in this context is targets versus measurements, and we'll come back to that in due course, no doubt. But can we try and get some context on this? So in example 17.229, which you just referred to us, we're talking about pH measurements now. It's not at all clear to me just reading 229 how the pH measurement is done. Is that explained elsewhere in the specification? Was there any expert evidence about that?
It's not explained in the specification. Mr. Dupin gave evidence limited to acknowledging that measured values are generally more precise than a target value. But if my Lord is asking about the particular instruments or mechanism by which it's measured...
Okay, so let me explain the question, all right? It's not, please understand, this is not your fault. One of the reasons for the scientific rounding convention is that it is recognised that, depending on what field one's talking about, the measurement techniques available are of greater or lesser degree of precision. Therefore, it is often the case that where you have a dispute as to the degree of precision with which a claim is expressed, there will be evidence as to what measurement techniques are being used as at the priority date and what degree of precision those measurements have, because that will be part of the common general knowledge with which the skilled person or team reads the specification. So, for example, let's take some other technique, like a molecular weight measurement. And so, maybe the priority date, everybody's using mass spec, and so you know how precise a mass spec measurement is, and therefore when you see a molecular weight, that's part of technical consideration from the common general knowledge that the skilled person takes into account in understanding the degree of precision. So, with the benefit of that explanation, do we have any evidence as to how precise, well, first of all, as to what techniques were being used for pH measurement in this field at the relevant date, and what degree of precision the skilled person would expect?
I'm very grateful, my lord. The answer to the first part of that question is no. There's no evidence about the degree of precision of the pH values were measured. In terms of the degree of precision with which the skilled team would expect, the judge made a finding about the degree of precision for target values. And that was based on some evidence from Mr. Dupin. And what he said, it's in paragraph 786, is that the patentee had stated target pHs at a much more general level, either to whole numbers or at most 0.5 increments.
Yeah, well, that's a different point. So he says it's clear pH values can be now measured to 1 or even 2. Where do we find 2?
There are some of the other examples.
Yeah. Next.
I will show those to my lord.
Just looking at it.
Example 18 and 19.
18 and 19, okay. Let's see, 7.21 to 10.52. Okay, that's interesting. And then 19.
19 at the top of page 46 records a pH rise 6.8 to, it moves from 6.8 to 10.6.
Well, that's not 2 decimal places.
Sorry, this is an example of where 1 decimal place is
Yeah.
used. Example 18 is an instance where 2 decimal places are used.
Right, okay.
And just, if I may, while we have this open, example 19 also records a whole number to 1 decimal place in the table 3, trial 1. It notes pH is 6.0. My lord, so just to finish off with the question I was attempting to answer, Mr. Dupin had given evidence that it's not unusual to record a measured value to a greater degree of precision than a target, and in cross-examination he said a target would not be an exact number. That was T3, page 349.
I beg your pardon, could you give me that reference again?
Yeah. So it's up to tab 17, page 460. And it's 349 of the transcript, lines 19 to 25.
This thing about the degree of precision is that they seem to use different things at different stages. I was just looking at example 7, where they go from 1 decimal point to 2 decimal points in the same paragraph. So in the early on, there's a pH of 10.5, and then at the end of that example, it's 10.09. And then There are other examples where they use round numbers as well.
Yes, my lord, that I will come to. That is one
Sorry, I
of
don't want
my third reason.
Okay,
But
I'm
yes.
sorry. But I'm just wondering
You're
what
absolutely
one,
right.
what's your submission as to what one gets out of this? Because they seem to use all three. They use round numbers, they use 1 decimal point and 2 decimal points.
So submission, my lord, is that what that shows is that the patentee well knew that they could use different degrees of precision to express pH.
Right.
And that they chose to express the pH value in the claim to 0 decimal places. And that's because they meant that it should be understood in that way. Okay, my lords, I've dealt with example 17. The judge and Mara considered that a different paragraph in the specification, paragraph 152, supports more precise construction, if I could do with that. It's at Sup 1 tab 2, page 31.
Sorry, you want your third point here?
No, this is still my second.
Still point 2. All right, that's fine. Just checking.
Which is nothing in the specification to support the more precise construction.
Right.
So paragraph 152, as Mr. Abrahams explained earlier, is about step C4 of the claim. And at the top of page 32, lines 3 to 5, it specifies pH ranges differing in 0.5 increments. And the final sentence also lists pH ranges with some 0.5 values. Now from this, the judge concluded that all whole number pH values used in the patent must be interpreted in the same way. For my Lord's note, that was judgment paragraph 787. However, the judge then adopted a construction of 8 or above in the claim, which is more precise even than this paragraph. Take pH 7.99, for example. That would fall within the range 8 or above described in paragraph 152, but it would be excluded by the judge's construction that pH 8 is an exact number. There's also no reason why all whole number pH values in the patent must be interpreted in the same way as paragraph 152. First, there's a clear contrast in the specification between this paragraph describing step C4 of the claim and the paragraph describing step B in the claim. Paragraph 126, if my lords may recall, is the one dealing with step B of the claim, which refers to pH raised to 8 or above, 9 or above, and so on. And here the patentee was deliberately choosing to specify ranges using only whole numbers. Second, the judge's approach sorry, I'm going too quickly. Second, the judge's approach contradicts the indication given by example 17, as we have seen. And third, my lords, the patent specification is not intended to be a puzzle, where the skilled reader must first identify paragraph 152, just one out of a 352 paragraph patent, and then realise that that paragraph is intended to be the key to unlocking the degree of precision intended in the claim. My third reason, my lords, I apologise, it's 4:15. My points do get shorter as I go.
Let's finish them.
I'm grateful. Third, the patent sometimes expresses pH values in whole numbers, sometimes to 1 decimal place and sometimes to 2 decimal places, as we have seen. This shows that the patentee clearly knew how to express pH values to varying degrees of precision and chose to express the pH range in the claim to 0 decimal places. That was recognised in Convatec as a powerful factor in favour of interpreting the claim as precise to the degree of precision with which it is expressed. We've given a reference to the relevant paragraphs of Convatec in 48D of our skeleton. The judge discounted consideration of the degree of precision used in the examples on the basis, as my lord has already identified, that they were measured values, not target values, as in the claim. That's paragraph 786 for reference. I have two responses to add to that. The first is that the points I've made about example 17 and about the different degrees of precision that the patentee uses in the specification apply irrespective of that distinction. And second, the judge's conclusion on the use of target value, it is inconsistent with his construction. If I could ask my lord to look at paragraph 786. Which is on page 292 of the bundle. This is a sentence I referred to earlier, which makes clear that target values are used in the patent at a much more general level than measured values. However, the judge's conclusion at paragraph 790 that pH 8 or above means exactly 8 is more precise than either of the options given in this sentence, whole numbers or 0.5 increments.
Can you explain to me what is your understanding? It's not. I appreciate you're attacking this, so in a sense it's not a question for you, it's more of a question for the other side. But I'm baffled by the distinction between a target and a measurement. Because how do you decide whether you've hit the target or not otherwise than by doing a measurement?
Well, my lord, we agree, and we made the point in our skeleton that a target isn't merely something to aim for. It obviously has to be achieved.
It's the limit on the claim. It's
yes.
How you decide whether you're within it or without it. And to do that, you have to do a measurement.
Yes, I agree, my lord.
Yeah.
So two more points, which are quite short. The fourth point is that the judge made a further finding in the judgment which points in favour of DSM's construction, and that's at paragraph 803, page 294 of the bundle. Here the judge was still considering construction, but had moved on to a different issue. And 3 lines down, there's a sentence that says, the other point to bear in mind, which the skilled team will be well aware of, is that the process of demulsification does not switch on when the pH reaches 8 or above. This is a technical reason against adopting a greater degree of precision in the claim than it actually uses. And my lords, fifth and finally, the judge considered that the words raising and or above in the claim changed the way that pH 8 would be understood. My lords can see that at paragraph 788 of the judgment. If I could ask your lordships to read the paragraph. The second sentence of that paragraph indicates that there's no reason, technical or otherwise, to interpret pH 8 as requiring exact compliance. The words raising and or above do not change the degree of precision with which the skilled team understands pH 8 in the claim. And there's also no reason why raising the pH to be within a range would be understood to imply greater precision than a single number.
Yeah, you're just making it more alkaline. You're adding base. Make it more alkaline.
Yes, my lord. Unless I can be of further assistance, those are my submissions.
No, thank you very much. Yes.
My lord, I deliberately didn't filibuster so as to be able to carry on overnight, but may I sit down tomorrow morning rather than now?
Yes.
Thank you.
So we'll start again at 10:30 tomorrow.
All right, table.